and thank you so much for staying in tune with us. We have come to one of the most interesting segment of this program. We have in the building with us lawyer Mboge from Married Bantan Chambers. Good morning, Mr. Mboge, and thank you so much for honoring our invitation.
Thank you very much. You are welcome.
So we are going to be discussing on matters of the verdict of the court that was being made yesterday with regards to Yankuba Touray'S trial. What is your take on the verdict of the ruling of the court?
Yeah, thank you very much. I personally, I believe it's a balanced judgment, because if you look at the scale of justice, you have two scales where you have to balance each side. And the punishment should always be commensurate with the offense that has been committed. So I personally feel that if someone has been murdered in cold blood, a punishment that is commensurate with that offense should be carried or levied by the court.
But in 2018, Gambia became the 86th party to ratify the Treaty of the International Covenant on the Civil and Political Rights, aiming at the abolition of the death penalty. What happened to that treaty?
Yes, that's an international treaty. It does not supersede the local laws of the country. If we are, in the process of implementation of international laws, the National Assembly should apart from the ratification of the international treaty, should also implement that treaty to be commensurate with the local laws. But ratifying that treaty alone is not enough, because our courts cannot apply international law over and above our local laws. So we are still a step behind in the full implementation of that treaty to make it commensurate with the local laws. That will lead to the amendment of our criminal code and criminal procedure code to abolish the death sentence.
I believe the death sentence is still entrenched in our 1997 constitution.
That is right.
So that is where Yankuba Touray's fall as a culprit to that, right?
That is right.
So would it have made any difference if Yankuba Touray's had complied with the TRRC to at least give his testimony, just like other victims or other testimonies that were filed in by the witnesses, rather?
Yes, certainly. The end result of his prosecution is as a result of his absolute, I'll use that word, disregard, not only for the TRRC, but also for the victims of the atrocities that were committed, especially in this case, the family of Koro Sise. It would have been better if at least you agree to testify before the commission, have a tug of war with our lead counsel, SFL, as it happened in the case of others. We have seen that of Edward Singate, we have seen even the notorious Alaji Kanyi, and many others. Almost all the co-conspirators in this case have testified. But the act, that's the TRRC Act, has given mandate and power to the Attorney General to execute the laws with regards to the TRRC Act. And there, he has the powers to say, fine, if you agree to testify before the commission, we'll let you go and wait for the recommendation of the TRRC. But if you refuse to testify before the commission, you fail the full force of the law.
All right, Lawyer Mboge, I will just take you back a little bit. That is with regards to Yankuba Touray'S verdict that was given yesterday at the High Court in Banjul. But in the issue of when the verdict was given yesterday, many people raised the question of, the law itself. And many people argued that the law should have been reviewed 10 years ago. Was that the case? Give us, the expert point of view, regarding that matter.
Yeah, thank you very much. Review of the law is not the function of the judiciary. just like Ali asked about the implementation of the international treaty, that is the function of the National Assembly and the executive. The executive proposes the amendment and send it to the National Assembly for implementation. And then the amendment will take effect. And that amendment will be the law that will be applied by the courts. The law, the function of the courts is to apply the law as it is and not as it should be. So this is the difference. The judge applied the law as it is and not as it should be or it should have been. So that is the function of the assembly together with the executive, that is through the Attorney General's office, who should have filed a proper bill to amend the criminal code and the criminal procedure code so that they will be in tandem with the amendment with regard to the international treaty on the abolition of death penalty.
So was that a fault or failure on the side of the National Assembly?
No, no, no. I will not say the National Assembly. That should emanate from the executive, because that's the function of the Attorney General's office. The attorney, but it's not only the Attorney General himself, but I will say the executive. When we say the executive, we mean the president, because the will power to amend the laws emanates from, although the Attorney General is the advisor, legal advisor to the president. Once the proposal comes from the ministry, it goes to the president for his endorsement, and then it goes to the National Assembly for implementation. But unfortunately, those steps have not taken place.
And we've seen comments that were, you know, shared by some of your colleague lawyers that the court was a bit harsh on Yankuba Touray's. Was it?
Yeah, it is difficult when it comes to sentencing. Sentencing is a matter of discretion. Discretion is a matter of the person who is carrying out the functions of the judge. If it was another judge, he may have a different conclusion. He may not even find him guilty. He may find him guilty, rather than murder, he may find him guilty of manslaughter. And even if he was found guilty, he would not have been sentenced to death by hanging. He may have been sentenced to death by execution, electrification, or firing squad. So it's all a matter of discretion of the judge. Now, but what I can say about the sentence, I believe it is in equilibrium. When you, behind the judge, almost in all the courts, you have a scale of justice. And that scale of justice is a symbol that this is the case that has been committed, and this should be the punishment. And these two should be equal to each other. So if you consider the case of, imagine the scene where a pestle is used to hit somebody to death. Not only that, he's not given a befitting burial. The person has been conveyed in a vehicle, crashed in the bush, and the vehicle is set alight on fire. That is more than murder itself. So, bearing in mind the acts that have been done even after after committing the offense, altogether, I think the sentence is a balanced sentence. So, it's not that harsh.
So could the process of them burning down Touray'S in his car aggravated the punishment that was given to him?
Exactly, because if it was only murder, he could have been sentenced to life imprisonment. Simple murder, without the steps that were taken afterwards by driving him up to a point somewhere in Jambur and then hitting the vehicle on a tree and then burning the vehicle with the dead body, with the body, to ashes. So that aggravated the offense, and that resulted to the punishment that has been inflicted by the court.
So today we are talking about Yankuba Touray's, and most of our audience will want to know how about his accomplices We have not had anything with regards to those people, their cases. Are they likely to fall in the same predicament like Yankuba Touré?
Yeah, that will be preemptive at this stage, because when I say preemptive, the TRRC is mandated by law of the National Assembly to make recommendations to the executive. And the TRRC is yet to come out with its final report. So the recommendations of the TRRC will determine the fate of those accomplices and conspirators. Some may be charged for murder, depending on what they have done, and well, some may be used as witnesses, like in the case of Yankuba Touré.
Yeah.
If you charge all of them for murder, you will not be able to get witnesses. So you charge some for murder and use some as witnesses. But that will all depend on the result and recommendation of the TRRC that we are all awaiting.
Because we are in a critical stage of our democracy. But first of all, was this really expected, a sentence of this nature, but considering the fact that we are in a democracy?
Yes, democracy is like in the local parlance, when you do anything, you get the result of that action. Now, democracy, like you said, means you reap what you sow. You get the reward for your actions. So as far as, like you said, democracy is concerned, it's talking about the rule of law. You apply what the law says, and that is what is done by the court. So that is democracy. It's not a question of the judge just hanging down that heavy sentence on him without having regard to the facts of the case. So the facts of the case, like it is narrated, is what led to the sentence that is handed on him.
So how about the fact that we are in a democracy and in this critical stage of our country, you know, where the TRRC, a lot of revelations came out, a lot of atrocities were committed in this country. Hope this will not be a threat to Gambia's reconciliation process.
Yeah, so many questions have been asked about this. And, I don't think it is a threat. I believe it is a step in the right direction. Why? Because we have to go back to the actions that led to the prosecution of Mr. Touré. His colleagues, conspirators, I will say rightly, who were with him the same day, the same time, the same offense, all came before the law. They respected the law, respected themselves, and complied with the law by testifying before the commission and telling the truth. Now, the case of Yankuba is different in the sense that when he appeared before the TRRC, everything has been done to appease him, to convince him, to plead with him, to comply and give evidence, and he will walk away free. We have seen the cases of Sana Sabali, we have seen the cases of Edward Singate, we have seen Peter Singate, we have seen a host of others who confessed on television. Now, the question that begs for an answer is why Yankuba Touré? That is the question.
Well, he was hiding under the shadow of the immunity clause.
Which does not avail him. It doesn't avail him. I don't know. He has a team of legal advisors, but immunity under the Constitution is limited. It's not general. Limited in scope to the execution of your duties as a minister, as a president. But this is obviously outside the functions of his duties. He was not appointed a minister to go and execute, to commit this kind of offenses. So a crime, no matter how small it is, does not fall within the immunity clause that he is seeking to hide himself. Civil liabilities, such as contracts that he signed, leases that he signed whilst in the local government, official acts, he cannot be prosecuted for that. There is an immunity clause that defends him on that. But outside the functions of his office, there is no immunity, unfortunately.
We understand that the law is very petty. What can set you free can equally drag you into the mud. Mm-hmm. So what is the probability of Yankuba Touré not being hanged?
Yes, this is just the beginning. There is a host of procedures to be followed. Firstly, he has the right of appeal against the decision. His lawyers will appeal to the Gambia Court of Appeal. That may take a year or more.
Okay.
And then thereafter, he has the right of appeal to the Supreme Court. And the Supreme Court will take a year or year and a half. So he has about 3 years to go until he exhausts the appellate procedures in the country. And then the judgment, after the final judgment of the Supreme Court, it goes to the president for his attention. It goes to the Attorney General for his advice to the president. And then the president will look at it, and again, he can commute the sentence and say, instead of sentencing him to death by hanging, I will commit it to a life sentence. Instead of serving a life sentence, he can pardon him and then allow him to go free.
After everything?
After all these procedures have been exhausted. So the probability of his being hanged is very slim, to be honest with you. Because I know, as a matter of fact, having the nature of the president that we have, that he will not sign the death warrant of Yankuba Touré. I can be assured of that.
So me thinking as a Sarahule here right now, the High Court has just given their verdict of him being hanged. And if the evidence that were presented could not serve him to be given a minor punishment, what do we expect if he even appeals to the court? Will it make any difference if he could not even get a minor punishment from...
It makes a lot of difference.
Okay.
It makes a lot of difference. The Court of Appeal is a court that is above the High Court. The Court of Appeal also can review the whole case and vary the sentence. Instead of death by hanging, the Court of Appeal can vary the sentence to life in prison.
Okay.
That is a possibility. And if he is still not satisfied, he appeals to the Supreme Court. We have seen the cases of Lantombong, Tamba, and Sajo Fufana in the treason case who were sentenced to death. I was in that case. But when we appealed up to the Supreme Court, the Court of Appeal affirmed this decision of the High Court. The Supreme Court acquitted and discharged them. So nobody knows what is going to happen on the appellate process. He may end up with a life sentence, and he may be acquitted based on the evidence that will be available to the court at the final case in the Supreme Court.
Okay, now considering the fact, of course, you mentioned that in the beginning that the sentence was a balanced one. But considering all the evidence that is presented, do you think that it is really sufficient to warrant the court to sentence him to death by hanging?
Yes, like I said earlier, sentencing is a matter of discretion of the court. When we impose a death sentence, that is the appropriate punishment for murder. Okay, the mode of execution of that sentence should also be prescribed by the court. Yes, and that is either by hanging, by electrification, by firing, or if there is any other mode of execution of that sentence, it's all at the discretion of the court. That is the presiding judge. But well, as far as the judge is concerned, that is the punishment that he feels is commensurate with the offense that has been committed. So that is a matter of discretion for the court. Like I said, another judge may find it in a different way. or may impose a sentence of death, but at the same time may say by life imprisonment. Yeah, so it doesn't matter. In the end, it is always the discretion of the court that determines the case at the end.
All right. Considering, of course, all the cases that are presented, and the TRRC will soon send their recommendation to the president, do you think that if such cases go to the high courts, you know, the same verdict would be given to those people as well? Or will there be any difference considering the fact that they complied with the TRRC regulations to testify?
Yes, certainly. There will be a difference. There will be a difference because the reason for that difference is because these are people who willingly came to answer to the DRRC, number one, and two, they voluntarily confess to the acts and atrocities that they have committed, and three, that serves as a mitigating factor. Mitigating factor is it reduces the weight of the offense that you have committed. Even in the same case, like you said, the same people who participated in the same offense, if they come before the court from the onset and said, yes, I plead guilty, I did this, I did that, that is a mitigating factor. Because in the end, the judge will have to consider that this man has pleaded guilty. That means he admitted, confessed to the court, he did not waste the time of the court, and he regretted his actions, and then he may have a lesser sentence than another person who was in the same group who said, I am not guilty. The state brought 9, 10 witnesses. It took 1 year to prosecute him. In the end, he may have a different sentence from the one who pleaded guilty.
So even in the case of Yankuba, who, despite the fact that he violated the rights, the acts of the TRRC, but if he pleaded guilty at the initial stage, do you
yes,
think?
the sentence would have been different. It could have been different, let me say it that way, because I'm not the presiding judge. The reason why it would have been different is because a plea of guilt is always a mitigating factor in sentencing. Now, the fact that he did not waste the time of the court is a mitigating factor. And thirdly, it is also an indication that, yes, this man has pleaded guilty because he has regretted what he has done. It's different from where you come before the same court and you say, I am not guilty. I did not do it. But in this particular case, we have to be mindful. Yankuba did not plead neither guilty nor guilty. He did not plead before the court. He still relied on his constitutional immunity as his defense, that he is not going to...
He refused to talk initially, but then came that he wanted to talk.
Yeah, if he did not talk, the evidence will be used against him. That means he has been given the opportunity to defend himself, but he refused to do so. And the evidence that is before the court is what will be used against him. But in this case, if a person refuses to plea in court, to say, yes, I did it, or no, I did not do it, the court is duty-bound to enter a plea of not guilty and then open the trial. And then the evidence will come to convince the court that, yes, he committed this offense before a verdict will be passed on him.
So in the case of George Floyd, that happened some few months ago when he was killed by one of the Minneapolis police officers. And in comparison with Yankuba Touray'S case, what is the major difference there? Because that man was not sentenced to death and he was not also sentenced to life imprisonment, or rather was given a particular period of year that he will be serving in the prisons. Yeah,
there is a lot of disparity between the case of George Floyd and the current case we have at hand. This is a police officer in the execution of his duties.
Okay.
The weapons he has, the uniform he is wearing, these are all mitigating factors. Even though it is a case of murder, but it is murder that was committed in the execution of his official duties to enforce security.
Okay.
He acted in excess of his powers that led to the death of George Floyd. But the sentence there will have to consider the fact that this man was employed by the state. He's wearing state uniform. He's in the execution of his duties. He has been doing this for the past 20 years, and this is his first time of committing such an offense. Those are all mitigating factors. But in this case, I don't know of any factor that we can call a mitigating factor in the sense that it will reduce the case of Yankuba. Because where it started from the TRRC, he was not willing to testify. Everything has been done. He did, I'm not going to say anything. I have constitutional immunity. From there, he went to the court, and at the court also, he refused to plead. That is a lack of cooperation from the onset. So there is no mitigating factor to reduce the weight of the offense that he has committed. If he had pleaded guilty in the High Court, it would have been different. Or even if he agreed to plea and say, I am not guilty, it would have been different. So it's a case of maximum recalcitrance. Sorry to use that word. Recalcitrance is refusal to cooperate with the due execution of the law. So that resulted to the verdict on him.
So I understand in such periods it's very difficult, especially for family members, to have to witness such verdict rulings that was being made by the court. And on one of the videos that is currently going viral, the brother of Yankuba Touray'S said the judge was biased.
Not only biased, some offensive words. He's a layperson, but ignorance of the law is not an excuse to anyone. We have offenses that are related to judicial proceedings. One, under section 106, subsection 1, paragraph A, if you act in any manner that is disrespectful to the court, either in the course of the proceedings or outside the proceedings, that is an offense under the criminal code. It's different from contempt. Contempt proceedings are when you are standing before the court and you show him disrespect. That is contempt in the face of the court. If you go outside the court, you do something or say something that disrespectful to the court, is also another contempt of court outside the court.
How about within the premises of the court?
Yes, it is still out of the face of the court. Contempt in the face of the court is when the judge is sitting and you are standing there. If this was said by the brother in court, he would have been in Maltu by now for contempt of court. Yeah,
now what happens to him now?
Now, it's a different set of procedure because if an offense of contempt is committed outside the face of the court, it goes through the normal police process of reporting to the police, get him arrested, get witnesses, charge him for the offense, go obtain his statement, and then charge him before the court. And then it goes through a normal process of hearing, calling witnesses, except when he accepts he is guilty, then there is no need to call witnesses. But if he denies the charge of contempt of court, then obviously witnesses have to be called.
So do you think in this case that is likely to happen?
Well, it is all a matter for the administrators, the judiciary. Because even if the judge himself did not file a complaint to the police that he has been insulted and disrespected, the head of the judiciary, which is the Chief Justice, also have the same powers to lodge a complaint to the police to get him arrested. He can be arrested for that offense. Yeah, that is contempt. Because we had a similar case in the same court where a brother was sentenced to jail for life. And the family who were there, when they stepped out of the court, they started abusing the judge. But that was within the hearing of the court. So they called them in and they were sent to prison for contempt. No need to call witnesses. If the judge sees or hears what they have done in his face, that is contempt in the face of the court. He can send them to mile 2 for contempt of court. But if he did not see it or he did not hear it, then it is contempt outside the face of the court. Then it goes through the normal police process of arresting him, charging him, and then bringing him before the court.
So we understand that the previous people that were investigating Koro's murder case were all dismissed.
Yes.
So if those people want justice for what they did to them, do they have any place in the court to at least hear their verdict?
Well, yes, every wrong has a remedy in law.
Okay.
Every wrong. Those who were wrongfully dismissed have a cause of action against their employers. Before the industrial tribunal that deals with workers, before the High Court that has jurisdiction to hear their case. Okay. That is if they are not reinstated. But I believe from the proceedings that have unfolded before the TRRC and before the High Court, I believe those who were dismissed for attempting to investigate that case will surely be reinstated.
See, think correct, local languages so that our viewers
Local
who are
viewers,
yes, can also understand what is going on here. I don't know the language you're comfortable with, whether wall of Mandinka, Fulani.
Let's go to Mandinka.
Mandinka, okay.
Yes.
Yeah, I think Sohna should go with
You
the Mandinka
can
version.
go ahead.
All right. Comme ka ko summarize the mamen kata jankulo ngalo ne ko Yankuba Touré ya sentence le to death pour ya hang pour na ay fa at the High Court. Bari sa ite be mune funo la mole woto ya fo in angale kangola bari sa lafta le mol fango ya lon ko membe kering Yankuba Touré la case.
Yeah, coming after Nyamen Angale Counter, we no in Mandinka, Puruna local listeners will understand Kamenfo. Coming yalo lua abenyamen sohna, I think it's sohna. He said it lua meseatale. We say that in Mandinka. When we say that, it means that the law is unpredictable.
For sure.
Unpredictable walam mo buka long abe laban na nyameng nibita kitiola. Because membe fudiring fudokono e kata kotle ya fudo firing ya itandi jojola walam witnessol memina ebe diamula o kola len jojo kana long abe menkela ida jeko ye menfo ya tumi men toñale ma sututale o amanke toñati ninga sututa fanan kuluro membe la kan ay manya menke ani ba kulula menna e nyanta kanyanale so amanyana kuluro la kan men dasata ay menke amanyana kuluro la kan men tambita ay menke so kuluro membe la kan aninga menke e nyanta kanyanale so jojo la jeroto ay kuluro men la kan walen ka sentence to death walen loi ya muta pour ya fa ka deng julo ka julo bula mola ka deng walen kanyanta afe aning ay menke ni ajuben the evidence ya mengi tandi walen diamo ke ko kenya mengi tandi walen ka dokota kulungo is a pestle turlang what they use
Kuda.
Yeah, that's right. Kata kamo lipa with it at the back of the neck. So niajiben the punishment that kuluro me ya lakan pruka den ning julola ani wo liparo wala kanyanta. That is the reason behind the decision.
Aboko e ka jibe la kuonyin tata nyame ani be kuonyin lala nyame.
Yol kanyana. Okay. Exactly. So niatara for instance I kidoleta I shoot I fa ni ba sentence la iba falale ya fanan shoot.
Okay.
By he would have been sentenced to death by firing. Okay. Niatara ya electrify le comme ya mutale ya kuramota ya bulala ya mas ya fa ni bete fa da mari fanam fala the same punishment yeah exactly so jojo la sentence kamunta aning kuo kita nyame afana ya kuluro lande wala nya
ka misal fe wala nya
exactly
bare kabri yo kuluro di yala kuno mo jamata ta social media ka fo haye kuluro men di Yankuba Touré la kuluro ning hasta bakale fo akata wala nyama ba
yeah nte personally ntema ajewo nyama because ntemu loi dokulalti I've been in this job for years and nte fonga kitio kele as a magistrate before and kuluro ning offense menketa nyanta kanyanale but ning ya juben meye kudata ay mo lipa ala fafata aning ka julota ka mari deng yalong luato ita fono la ya mari lipa for ya fa because that will be harsher wala kolayata fang dan ka deng because ka more deng it will take some minutes or 30 minutes not more than an hour to pray a new yeah exactly but punish I menke ka fa akamunta if inyanta fana fala wala nyama so ning social media fine be democracy like you said earlier people are free to say their mind but even ngafo nyameng the same court we have 12 judges in the high court but near the another judge la ala miro na la jero ane nyindola miro ni jero si fatanola because molla handi kakilol ni miro ni sondo mol mankile so this is the reason Jaite the judge who Justice Jaite who presided over the case ateaje nyameng ayake wala nyama near the another judge like a lady judge okay fine I've seen other judges who sentence people to death recently there was another case, although it's not a popular case like this one. Meye muso rape suffocate with a pillow. Kularamo press fire newborn. He was sentenced to death by another judge, and it's a female judge. So Ibajala, in that case, the judge who is a lady will feel that if it was me, how will I feel? Now, this one is man to man, and I don't know why the CJ assigned it, Chief Justice, assigned to Justice Jaite, but you know, CJ also have a discretion. Discretion walang akajubele mentioning kitio keno anyama.
Dol fananko politiko bulata konol.
Well, I'm not aware of that politics. I'm not aware of that because as far as I know, I've been working with Justice Jaite for years, but I cannot tell you which party he belongs to. He never saw it. And then long, whether he belongs to this party or that party, he even doesn't talk about it. Because judges are public officers, and they are not supposed to involve in politics. Even if he belongs to a political party, abukai tandi mola ko ntebe nying party karle onka nying party karle support. I've never heard of it, and I've never seen it.
Dol ba fo kan ko politiko be nyim kono la ba dol fana yayi tande ko say gambe ya fansoto la fansoto mo ya lon ko at least na loi bundal ye fansoto la pour que kol ke faye without the influence of the executive.
Yeah, I want to assure you mlafta nyingi tandila itela aning la moirlano pour sa lonko B na judiciary is 100% independent. 100%. Lata wala akweta maset. Because the previous regime na interference men besoto in the judiciary today is zero. President, executive, attorney general, no one nte la londoto. No mam nenema moy nenema je the president or the minister I telephone a judge carry call or a magistrate carry call akai lafta nyinela. Lafta nyina kenyena, lafta nyinkiten, lafta nyinkiten. I'm not aware of it. As far as I am concerned, I can speak for myself. But Kafuko executive interference, no, that one is zero. I can assure the general public that there is no executive ma dadu nying kitioto. The only thing is the former Minister of Justice, that is Ba Tambidu, wole ya recommend to ya prosecute. Adu fanang luale sembo diala puru ay TRRC nyina doku sone andabulu. Nka mol men foten melni Yankuba da mabeta nyinto ibe tamakan freely in the street. People are commenting about it. Yes, but wo fanang luale o sembo di minister la is the powers given to the minister by the TRRC Act. Nimmen cooperate with the act is ibulaeta for janning recommendation mina wati men. But wo recommendation be intel dodota fonola for prosecute la for the prosecute la. For be charge la murder or manslaughter or for be pardon. They can even recommend for their pardon. President Yamfe because national in the spirit of national reconciliation is sontale inata tonyafo dunia be nyatile wala kontela nganyeke. So what that is enough for them to be pardoned.
Kuluro fanala o mu fanna me yalanko akumaya tabake ya for angale kangola kom ita hangla immediately come I process the sort of asa appeal nol o fana sene ande mole saje mole ya understand because our process kumaya and kuno kom momo ba for la maybe is a hang no anytime soon.
No. Hanging this is the decision of court ya decide ko nyanta afala by hanging kajulu ta ka deng. Now, from today, I'm sure our lawyers are working on our appeal to the Court of Appeal. Okay. Now, after the Court of Appeal, records, eka kitio ke menna, appealo ke menna, kitio birad dati watu, fala bandula, eka be type le, ya be prepare, ya compile in a book. And I can assure you, Yankuba's file is 1, 2, 3, 4 files. Bulk among the file ndingoti file ba katangol. Ibe all be de dalale ya kafunyoma yo samba Court of Appeal. Court of Appeal minao kitio be kumakangol from adati dula file la bandula. Iba be saying kanale. Ibuka sedol kumande. Ye memfo. Kaito bala. Ika kaito le jube. Ni witness ko teng, nyin ko teng. Ka Yankuba ko teng ala muso ko teng abale muso ko teng adingo ko teng anen jojo ya la nyadili fa benda fa man ben fa tilinta fa man til wala ka 5 ans alright ningol ya 5 ans ye sembo soto ya confirm ko jojo la kitio tilintale ay kuluro mel la kan akanyanta wala amankanya isa no ya fo instead of ya fa by hanging isa falino ya for ya samba life imprisonment. Sa samba no kasoto for life. Okay. Ningo fana banta still ala lawyer another found ninga man satisfied. I write soto again, I appeal to the Supreme Court. Saying member gena kolandila High Court Justice Jaitela Kitio, Court of Appeal la Kitio, it all be kafula nyoma. We were talking of 4 files. Now it's going to be double. Wo bebe de la koteke ya samba Supreme Court. Supreme Court fana mina jaitela kitio sekan Court of Appeal ta sekan itel fanale na decision ta whether jojo la kuluro atilinta amantiling akanyanta o amankanya foba falina foba yela mandila foba la atalala foba la fala because malai be fel lala wakan isa talano le but dead by hanging you cannot put anything on top of that. Yeah, so ningo be process of banta still wo judgment no iba kila attorney general ya iba kila president ya ni atara ya confirm ko anyanta fala. All right, that's ni Supreme Court ya confirm but ni woli ya falling there's no need. It's only death sentences men kata president ya pour ka 5 ans ka juben. Okay, president fana sembo soto to commit the sentence ka tala. The president has that power. I sembo soto ka yamfaye completely wala ka pardon. Okay, I sembo soto fana afo nteyam fala ala debt waranto ala deda Minister of Justice wala be waranto deda ya nate president ya aya sign nim president ya waranto sign straight is going to execution.
Okay, what idea
So no. But this is about 4-5 years to come. Nyamake Johnny Kuti. It's a long process to go. Yeah. So before Nimbe final settle, because ntelanga treason case menke Lantombong and Sajo Fufana from 2011 up to 2016, 5 years. Mbela Kitiola Janembe for the Supreme Court.
So first sign thing abetar la remand custody la for the Basambala mile to prison.
Yeah, now he's a convict.
Okay.
Convict. Melbe Kitiola ekawole samba remind.
Remind, okay.
Mella Kitio Banta ekawole samba prison.
Okay.
So now he'll be under prison custody for janning ala case be banna watime.
Okay.
Amamba follow. Mula mera bantale barama. No, there's a lot of process. Time membe tutaje. Menyanta kelaje wala siata menketa.
Monketa.
Yeah. There's a lot to be done in the case.
Okay. Abaraka bake lawyer Mboge molse wota it mabeta mola studio kona nyame jambi pour ka katcha Yankuba Touray'S trial case da be tentula be jayla ila mabi na jang